Welcome, everyone, to the College of Law. As the dean here, I am delighted this afternoon to help kick off the 2017-18 Health Law and Policy Conversation Series, which is made possible by the Epstein Health Law and Policy Program and Family Law Policy Program. Today, our first speaker in this year's series, Professor Naomi Cahn, will speak about the new art of family, ART capitalized, developments in the law of assisted reproductive technologies. In particular, she will explore how recent developments in assisted reproduction generate new questions about the recognition or non-recognition of parents. Following her remarks, my colleague Robin Wilson, who is the Roger and Stephanie Joslin Professor of Law and the director of both the Program in Family Law and Policy and the Epstein Health Law and Policy Program here at the college, will present Professor Cahn with the Lifetime Achievement Award in Family Law that is named in honor of our esteemed emeritus colleague, Harry Krauss. And then after that presentation, there will be a Q&A session. It's now my pleasure to more formally introduce Professor Cahn, who is the Associate Dean for Research and Faculty Development and the Harold H. Green Professor of Law at the George Washington University Law School. Professor Cahn is the author of 11 books, including her most recent Homeward Bound, Modern Families, Elder Care, and Loss, as well as numerous law review articles and book chapters covering subjects including fertility, marriage, family, and trusts and estates. In addition to her roles at George Washington, Professor Cahn is a senior fellow at the Even B. Donaldson Adoption Institute. Prior to entering the Legal Academy in 1993, Professor Cahn practiced with Hogan Lovells. I knew it as Hogan Hartson when I was a kid. That's the firm, by the way, that Chief Justice John Roberts was a partner at, I believe, in Washington, D.C., and also with the Community Legal Services in Philadelphia. I've had the good fortune of hearing her speak several times in recent years, including here at the College of Law, and without fail, I always come away better for the experience. So with that, let me turn it over to Professor Cahn for her presentation. Thanks.
Thank you. Thank you for that amazingly generous welcome. And I should, as I figure out how to turn this on, there we go. Hopefully you can all hear me now. Yes. I should disclose that I actually worked for Chief Justice Roberts on one project when I was at what was then called Hogan and Hartson. So good for the dean for mentioning that. I am absolutely delighted to be here. Thank you, Dean Omar. Thank you, Professor Wilson. Thank you to the Health Law Policy and the Family Law and Policy programs for inviting me to be here to talk about a topic that is actually going to bring together health law and family law, hopefully in some wonderful symbiotic way. I have flashed up there a picture of Professor Krauss, who is well known for many, many types of work, but he was at the forefront of making sure that non-marital children were recognized in family law and in the law of parentage and were accorded increasing legal rights, and that their fathers were accorded increasing legal rights. And his work is particularly important in an era in which 40% of children are born outside of marital families. And so I should note that I'm particularly pleased to be to be receiving the Harry Krauss Award because he focused very much on the rights of children. And similarly, I'm going to be focusing on the rights of children. I'll be focusing on the rights of children in a different context, not in the context of illegitimacy or non-marital children, but in the context of assisted reproductive technology. And I will be talking about the future of anonymity in assisted reproduction. I'll be talking about sperm donation, about surrogacy, about egg donation and embryo donation. I will talk generally about sperm, egg, and embryo donation in the context of gamete donation. And I want to focus on how the future of anonymous collaborative reproduction is under assault in a variety of ways, both from new technologies as well as from donor-conceived offspring asserting rights to know their identities. So I'm going to be looking at 3 different questions. What's the current technology of assisted reproductive technology? What is the future of assisted reproductive technology? And it's the future that calls into question the need for donor gametes. What is the law on assisted reproductive technology? And then what is it that needs to change? And I should say, of course, the play on art in the title for the talk, the play on art here, assisted reproductive technology, and I mean any method that allows for achieving pregnancy by assisted means. That is, any means of achieving pregnancy that allows for outside intervention, that allows for collaborative reproduction. This is just a moment for me to note the language in this area before I jump into the substance of what I'll be talking about. The language in this area is highly contested, and depending on my audience, I get questions about why I have used the particular language that I used. To many children who are conceived through assisted reproductive technology, to many children where there are sperm donors who have contributed to their creation, or where there are egg donors, I call them donors. First of all, they're not really donors because they're often paid. You may have seen ads on campus for egg donors, large amounts of money depending on your SAT or I guess LSAT. And often people are paid a great deal of money to be egg donors, paid a little bit less to be sperm donors. So they're not really donors, they are paid providers. So the language here starts off being kind of strange. And then the next piece of the language is, if you talk to donor-conceived offspring, they will often say, not my donor. They literally will say, my donor is my father. Now, they're not talking about legal father. They're talking about their biological or genetic father, but they do view this person as their father, or an egg donor as their mother. So I want to kind of as a footnote just say I will be talking about them as donors, even though they are paid, and even though many donor-conceived offspring view them as their parents. The other thing is I will sometimes call them donor-conceived children. I am often corrected by donor-conceived children who say, well, we're over the age of 18, we are donor-conceived offspring. But I'll be talking about them at the time that they are born. And then to dramatize the stakes that are at issue, hopefully we're going to show a clip from a 2013 movie. So if this works, it's Delivery Man, Vince Vaughn. Some of you may have seen it.
I guess I just haven't found one yet. David Wozniak, in 1994, you donated to a fertility clinic anonymously. Apparently there was a mix-up at the clinic. What? You are the biological father of 533 children.
What? It is impossible to be the father of 533 children.
It is impossible to be the father of 4 children.
How would a normal person handle a situation like this? A normal person would not be in this situation.
You're in trouble, David. The kids are suing to find out who their biological father is.
What do we do now?
This envelope contains the profiles of your children. Do not open it. I know I shouldn't, but I picked out one of the profiles. I just picked one. Worst idea ever.
I'm an actor missing the audition of a lifetime right now.
I'll take you to the coffee shop.
Who are you, man?
I can make you a cup of coffee.
All right. So that shows, perfect, thank you. Thanks, Janae. So that shows some of, I mean, it's right, it's Hollywood's version. Some of you may also seen the film called The Kids Are All Right. Again, similar issues. The question is, what happens when children of a sperm donor or an egg donor want to find out who the donor actually is? And this shows you a little bit about what might happen, at least in the Hollywood version. Now, I should say that the reason the children need to sue to find out his identity is that the history of assisted reproductive technology is actually wound up with secrecy. In 1884, that's when Dr. William Pancoast allegedly performed the first assisted reproductive technology procedure using donated sperm. At that point, in this first recorded case of artificial insemination, this Philadelphia physician treated a couple's infertility by injecting sperm from his best-looking medical student into the woman while she was under anesthesia. She gave birth to a boy 9 months later. He never told the woman what he had done, and apparently the husband, who was infertile, only found out several years later. The account of this first procedure was not even published until 1909, after Dr. Pancoast had died, and one of the medical students who was present at the time of the insemination published the article in the Medical World Journal. So secrecy has been involved in the entire process, the entire history of assisted reproductive technology. Now, just to give you some of the highlights of what's happening in assisted reproductive technology, until the early 1950s, in order to create children from donor sperm, it had to be fresh sperm, to wit the medical student that Dr. Pancoast used. In the early 1950s, technology developed so that sperm could be frozen. The sperm bank business, including a very famous Nobel sperm bank, came into existence in the 1970s. In 1978, Louise Brown, the first in vitro fertilization baby, was born. 1984, embryo freezing becomes possible, and in the 2000s, egg freezing becomes more common, and there are even, for example, some law firms that will pay for their associates, generally associates, for their associates and partners to freeze their eggs in order to preserve their fertility. So that's a brief history of where we are now. I'll talk in a minute about where we are going. In terms of the numbers of where we are now, the Centers for Disease Control collects information from infertility clinics. And more than, first of all, there are close to 200,000 cycles of assisted reproductive technology performed each year. So that means 200,000 cycles in which sperm and eggs are manipulated outside of the parents' bodies. And of those cycles, about 18 to 20,000 involve donor eggs. Each year, more than 10,000 donor egg babies are born. Sperm, actually, we have no idea how much donor sperm is used. In part, the technology for using donor sperm is very different. Anybody with a syringe can use donor sperm, but also nobody actually collects information on how much donor sperm is used per year. There's a figure of $40,000 per year. 40,000 cycles per year. The reason for that figure is in the late 80s, that was an estimate that someone gave. Nobody has any idea how many sperm donor children there are. The CDC collects information only on donor eggs and assisted reproductive technology cycles. Several hundred children born from donated embryos each year. In terms of surrogacy, there is a growing use of surrogacy. And surrogacy today takes the form generally of one woman gestating another woman's egg. So it's called gestational surrogacy. And this is an image of the number of surrogacy cycles performed per year and the percentage of assisted reproductive technology cycles that they compose. So between 2009 to 2013, about 2.5% of all assisted reproductive technology cycles were these gestational carrier cycles, and there were about 10,000 children born. Interestingly enough, over half of these cycles were performed in 4 states. Can you guess what one of those 4 states is? Illinois. California, Connecticut, Texas, and Illinois are there at the top in terms of being surrogacy friendly, although I do have to say California does edge you out because it had the highest number of gestational carrier cycles in the country. Nationally, about half of these gestational carrier cycles use donor eggs. So that means in these situations, just to return us back to this idea of donor gametes. So in these surrogacy situations, there are the intending parents, there's the surrogate, and then there's going to be an egg donor. In terms of the future of collaborative reproduction, that it suggests, at least in the short term, a continuing need for donors. But in the long term, advances also suggest otherwise. So just a quick look at some of the more exciting technologies that are coming down the pike. Mitochondrial replacement therapy, which actually does still require a donor, and then in vitro gametogenesis. With many, I should note that many heterosexual couples, because of the advances in technology, actually no longer need donor sperm. They may still need donor eggs. But it does appear that the majority of those seeking sperm donors today are single women and lesbians, although, as I said, we have no idea of just who is using donor sperm. In addition, single men and gay male couples still need eggs and a woman to bear them, although, of course, the costs of surrogacy and the costs of finding donated eggs preclude many people from accessing that particular technology. Sperm is much less expensive. Donor sperm is much less expensive than is donor eggs. So in terms of technology, meet the law, 3-parent babies, mitochondrial replacement therapy has now been okayed, for example, by the UK Parliament. And that's just an example. This is just a picture of just how it all works. Essentially, it replaces damaged mitochondria in the intended mother with mitochondria from another woman. Here is Dr. John Zhang from New Hope Fertility Center in New York City, holding a baby who was created in Mexico and born in the US to Jordanian parents through spindle nuclear transfer, which involves removing the nucleus from one of the mother's eggs and inserting it into a donor egg that has its own nucleus removed. The resulting egg was then fertilized with the father's sperm, inserted back into or transferred back into the intending mother, and voila, we have a baby here. Now the baby has relatively close to very little percent of donor gamete from the woman from the donor woman, but it does involve, I mean, this future does involve a donor. I should note that when the United Kingdom okayed this technology, I guess it's 2 years ago, to deal with parental rights, it denied any parental rights to the mitochondrial donor, establishing that the intending parents were the parents of the child. Even more exciting, I think, than MRT, and potentially more accessible, although we don't know, MRT is an incredibly expensive procedure, is in vitro gametogenesis. And the process of in vitro gametogenesis, it refers to the development of eggs and sperm in a culture dish. So far, it has been tried only with mice, but last year, researchers in Japan through this process, created viable eggs from the skin cells of adult female mice. So let that sink in. So they created viable eggs from the skin cells of adult female mice, and these viable eggs created from skin cells were then fertilized with naturally derived sperm from male mice, and the resulting embryos produced healthy, fertile pups. So whole new technology that all it needs to do is to use skin cells of adult skin cells, and a gamete can be created. Now, it's not coming anywhere near us anytime soon. It's still very much in the development process. But as a result of this, it means that it could spell the end for donors, because it could mean that actually one person, 2 people, 3 people, we could have thruples, we could have 4 people creating gametes with this new technology in order to end the use of donor gametes. Okay, so the final piece in the future of anonymity is, I don't know if anybody's done 23andMe or done anything similar to try to find out your genetic backgrounds. You can find out an enormous amount by just swabbing the inside of your cheek, and there are these improved searching techniques that are available from genetic testing and from the internet. For example, I know a man who found his egg donor just because he was looking at Facebook profiles for some other reason, completely no idea, and then he realized he was looking at his anonymous egg donor. Ryan Kramer, who's been an activist for the rights of donor-conceived offspring, literally swabbed the inside of his cheek, sent it away for genetic testing, and then was able to find his donor, the person who had contributed the sperm. I should say Ryan and his donor and Ryan's mother are all very, very friendly. But it means that any promise about the future of anonymity has to be taken with more than a grain of salt. It has to be taken with the advances in DNA testing, because it can be incredibly easy to find one's relatives in this way. So the technological capabilities are making the future of donors and the future of anonymity itself, calling that into question, both because of the advances in genetic testing, but then advances in the technology of assisted reproductive technology itself. So where is the law? Well, health law steps in to determine the safety of the gametes and the medical procedures. There is testing of both donor eggs and of donor sperm to make sure that to make sure that there are no sexually transmitted diseases that are involved. Very, very little genetic testing that is required by federal law, at least, with respect to whether or not these donor gametes carry various genetically related diseases. Some banks, some egg clinics will do some additional testing, but it is not required. And I should say that there's a study of egg donors that tried to test just how accurate their representations were when they applied to become egg donors. And on something as easily verifiable as weight, about 50% of the women underestimated what their weight actually was. And so there's not a good way of verifying the information that is provided, although there is this health law does, so health law minimally regulates in this area. It does, as I said, just step in with respect to whether or not gametes are, whether they transmit sexually transmitted diseases. Family law establishes parentage. And coming back to Professor Krauss, the Uniform Parentage Act, which he was instrumental in helping to draft in 1973, has been updated. It's actually been updated 2 or 3 times. It was updated in 2002 with minor adjustments in 2000, updated again in 2002, and the most recent Uniform Parentage Act, which I think Professor Wilson was involved in advising, just was issued this past summer. So I'm going to talk about that in a minute. So family law establishes parentage through the Uniform Parentage Act and state laws, and slowly the rights of donor-conceived offspring. So in terms of the identity rights of donor-conceived offspring, I want to talk about 2 different aspects of that. One is rights of donor-conceived offspring to find out who their donor is, and then I just want to briefly talk about connections between donor-conceived offspring and their donor-conceived, their half-siblings from the same donor. So in terms of, are your parents your biological parents, right? Of course, there's the legal parents, and then there's the biological parents, or biological donors in this case. Interestingly enough, for children of married parents, again, this is really hard to measure, right? Because how many married couples get tested upon the birth of their child to make sure that they are, in fact, the genetic parents? But at any rate, there are all kinds of estimates as to whether or not there is that is whether or not the husband is actually the father, the biological father of the child to whom he is a legal parent. The estimates are actually somewhere between, 1 to 7%. I think the most accurate studies are about 1 to 3% of the legal parent not being the biological parent. Of course, for donor gamete children, 100% of the legal fathers or mothers are not going to be the genetic parent. In terms of comparative comparisons, what's going on in the rest of the world, it's important to note that Sweden led the way in removing sperm donor anonymity in 1985. Since then, Switzerland, Germany, the Netherlands, New Zealand, the Australian states of Victoria, Western Australia, and New South Wales, Iceland, and the United Kingdom, among others, have removed anonymity when it comes to donating sperm or eggs. And there are claims that international law validates the claims of donor-conceived offspring who want to know who their donors are. The legal infrastructure in the United States, assisted reproduction, much more generally, technology, science, and practice have always preceded legal regulations, particularly true in the area of assisted reproductive technology, where in the 1950s, women who during a marriage with their husband's consent had used donor sperm, when the couple got divorced, courts would call the child an adulterous child because it was not the husband's sperm which had fertilized the egg. It was documented. So art, science, and practice have always preceded legal regulation. For screening Generally, as I said, there's relatively minimal screening. It's typically contracts that control that. And then, of course, some practices like making sure that donors are not responsible for any children born from their donated gametes need legal support. Just on Monday, this man wrote me saying, I'm a prominent actor and I would like to become a sperm donor, but I want to make sure I don't have any legal rights or obligations to the children. What do I do? Who do I turn to? So that certainly is something that needs legal support. In the US, we have issues involving adult privacy rights, particularly for donors in the past who provided eggs or sperm under a system in which the banks or egg clinics guaranteed them anonymity, versus what we have are offspring's rights and interests in knowing their genetic origins. And so these are just some of the legal claims. Adults have a fundamental right to know personal information about themselves. States have a legitimate role in facilitating the provision of this information. Withholding this information violates legal equal protection guarantees by denying these children the same rights as other people. And offspring should not be bound by decisions on anonymity made by birth parents and, for that matter, adoptive parents at the time of the adoption or the conception. Increasingly, donor-conceived offspring are advocating for additional information about their donors, and of course, an increasing number of couples. It used to be that, and it was women at that point, who were given donor sperm. Women and their husbands were told not to tell anybody that this is what they had done. And so it was possible for them to cover up the use of donor sperm. No longer true today, given that we still, because in vitro gametogenesis is not yet a thing, today we still need eggs and sperm in order to create children. I'll just briefly run through sibling rights in terms of donor-conceived offspring connecting with one another. The law is not very good at recognizing that siblings who've grown up together have rights, and it's not particularly good when it comes to donor-conceived offspring connecting with one another. There have been a few cases. I've been involved in at least one, but it's not a claim that is brought a great deal. I think we'll skip the adoption analogy, but there is an adoption analogy. In terms of where the law is today, some states are actually moving towards disclosure. Washington state law permits an adult donor-conceived individual to access identifying information unless the donor has indicated this is impermissible. Utah recently passed a law giving children conceived via sperm donation, it covers sperm donation, not egg donation, access to the medical histories of their biological fathers. Note that in the absence of this legislation, donor-conceived offspring don't even have access to the information to the medical information. And then the final legal piece is the Uniform Parentage Act, which, as I mentioned, Professor Wilson was involved in. Just this past summer, there is a new provision, not adopted by any state yet, that requires fertility clinics to collect information from the donor. The donor must sign a declaration on whether the donor agrees to disclosure. Even if the donor has not consented to disclosure, the clinic must take certain actions. So then the question is, whether we should be adopting new laws, whether we should go even beyond the Washington, Utah, and Uniform Parentage Acts to require disclosure, to establish mandatory registries, for that matter, to set limits on the number of donations per person, so we don't have that Vince Vaughn delivery man situation, and then to perhaps amend the Family and Medical Leave Act to give donor-conceived families more rights with respect to connections among one another. I'm going to close with some guidance from Professor Krauss. We may answer the and this is, you can just substitute, these are his words, whether legitimates and illegitimates. We may answer the complicated question of whether they are situated similarly for the fair purposes of a particular law, but what we really need is uniform legislation that centers on the interests of the child and embodies the equality principle of the 14th Amendment. Thank you.
That's just excellent, thank you, and cute, wow. Just great video clips, great images. So I'm Robin Wilson, I direct our Family Law and Policy program as well as the Epstein Law and Policy program. And while both programs are sponsoring the event today, the last piece is really something that comes out of family law squarely. And because of our emeritus faculty member, Harry Krauss, who was a giant in the field of family law, we thought it was important to recognize people who had not only moved the dial, who had really impacted the law, like Harry Krauss, but also people who were incredibly generous to their younger colleagues, like Harry Krauss was, not only to me, but to many others, I think including Naomi. And we're pleased today to award the Harry Krauss Lifetime Achievement Award to Naomi Cahn. She joins giants in the field, like Harry, like Bill Eskridge at Yale, and like John Whitty at Emory. And like them, she has left an impact on the law. Her work has been cited, for example, in the New York Times, the Washington Post, the Christian Science Monitor, the New Yorker. There's breadth. In terms of the people who look to Naomi and her work for guidance on a number of issues, including this. She's been one of the most impactful scholars in the field. She's routinely listed in the top 10 scholars in family law. I actually think if you adjusted for years, she would blow the entire field away, including Martha Feynman, but I'd have to do that calculation. In any event, and like Harry, she tells me this morning that she's been tapped by the Uniform Law Commission to be a reporter for a new act. Is that right? Possible new act, which is about economic rights in families.
Economic rights of non-marital cohabitants.
Yeah, and so actually we were just on this in family law this week. And by the way, the short answer is there are very few economic rights for non-marital families right now. As I say, they are crappy remedies. But more importantly, like prior recipients, Professor Cahn is really giving to her younger colleagues. I think she alone can be credited for bringing so many diverse voices into the field of family law and actually making family law rigorous and respected. And just on this point, one small thing. I remember when I was a baby law faculty member, my son was still a toddler. I sent my second article out. It was called The Cradle of Abuse, and I was writing about incest. So I'm very freaked out, worried about my piece, want to make sure it's right. I send it to Naomi Cahn. Then I sit down at the pool with my son, I drink a beer, I'm all happy, I'm patting myself on the back, and I swear 3 hours later, she has read that entire piece and given me pinpoint page-by-page comments, and it stuck with me. So I immediately sent her everything after that point, I think until very recently.
I can't read everything.
No, I know, but it was stunning in terms of just being such a generous colleague. It was really stunning to me at the time. In any event, we could not be more pleased than to recognize Naomi Cahn for her contributions to the field, to us as colleagues, and really just to the mental map, as you see here, of what family law looks like and what it's likely to look like going forward. So it's my honor to award for the program Naomi Cahn the Lifetime Achievement Award in Family Law.